Okay, so we're into Intro to Legal Studies, and this is our ethics unit. This is just an introduction into ethics because, of course, if you're doing paralegal or Pathway to Law School, or I think almost any of our other programs under legal studies, you have to have the ethics course. And it's really important because ethics in the law are not necessarily optional. A lot of times we think of as ethics of like, what should you do? What can you do? Like you could do many things. I don't have to help an old lady across the street. That's not required. Maybe I should, maybe that would be nice, but it's not required. It's not the law. So in the law, when we say ethics, we're talking about our professional ethics, and those are very much required. They're not optional. Even though, so you might think, well, what's the difference? I don't know why they've called them ethics then, but it is sort of like how to make the right choices, but in this case, they're required. And it does apply to you whether you end up being an attorney or a paralegal. Paralegals will be under the kind of the giant umbrella of the attorney ethics and will have to act in accordance as well. And so it really falls on the attorney to make sure the whole team is following the rules. But you don't want to run afoul of them. And they're there to protect the client and then also, to protect the attorney from getting, close to a problem. So we have a whole class in that. So just think of this as kind of a true introduction right into that area. So in California, we have a couple different things. And I already know that a couple of these slides are out of date, but that's okay. So our legal profession is regulated by the legislature, right, through Business and Professions Code that they pass, the California Supreme Court, and the California State Bar, right? So you get the State Bar rules from the State Bar and the California Rules of Professional Conduct from the Supreme Court. So kind of all these three entities, for the most part, are coming together. And then you have what we call interest groups or professional associations. So maybe some of you guys can like raise your hands with your little emojis. Are any of you members of Orange County Paralegal Association right now? Anybody? Any of you joined as a student member? Okay, I don't see any hands. Okay, I may have Kai jump in. She's a past president of Orange County Paralegal. She teaches Saturdays for us, and she's awesome. So Orange County Paralegal is, let's see, someone chatted. Everyone's saying no, not yet. Well, I know you all are going to want to join. Orange County Paralegal Association is like a subset of NALA, National Association of Legal Assistants. And then you have, and Roger is a member. Roger, would you recommend it that people join? Even in the era of kind of COVID, they're doing a lot of online trainings. And I forget, is the student membership like $40 and then you get to attend all the events? Let's see if Roger answers.
Oh yeah, I think it's, I've only been to one meeting so far, but it's, so far it seemed like a good opportunity to, kind of just see everybody in the field and whatnot. There's actually a fair amount of Santa Ana College students. I guess they have liaison students or something. At least I noticed that in the meeting that I went to.
Yeah, they work with all the colleges in the area. And so they'll have I've seen 2 to 4 students be like the liaisons. And so then your role can be kind of to make sure that information of events gets to the professors, or in the past, I've had the liaison and I don't know who they are right now. So Roger, is it you? They'll even come make announcements sometimes if they're in my class or anybody, of the upcoming event. Normally, we would have had the big spring conference and it would have been last weekend. So, and that turned into a Zoom event with programming that maybe some of you attended. So NALA, so Orange County Paralegal is a subset chaptered under NALA. Then you have National, I think it's Federation of Paralegal Assistants or National Federated Paralegal Association. Oh geez. And then the American Bar Association. So these are professional societies, professional interest groups. So they do not regulate the industry. The American Bar Association can't take away someone's bar license. things like that. But they do have sort of an important advisory role because they bring together professionals and they do research and have meetings. And so they'll often recommend what the ethics rules should be, or, you know, recommend different things. So, and in some cases, some states, the ABA has what they call the model rules of professional conduct. And some states have just adopted those as their ethics rules. They've just said, we are going to adopt the model rules. Those are our ethics rules. California has not adopted the model rules from the American Bar Association. We make our own rules, right? Kind of not surprising. We often do our own thing. So we have some that are very similar, but we have our own rules from, you know, the business and professions and rules of professional conduct and all of that. So sometimes you'll hear people talk about the model rules from the American Bar Association. They're just, you know, examples, they're suggestions, they're not regulations or regulatory for us. And so they are that, they're just a model. But if you ever take other classes or kind of, you know, if you end up going to law school, you'll hear more, or if you end up moving to another state and working there, you might hear more about that. So the first thing we always emphasize is in this area, who can practice law. So some of this, you're like, geez, I've heard this so many times before, but, you know, we always want to emphasize, and all of our constituent groups, you know, want to make sure everyone knows this. So only active members of the California State Bar can provide legal services to consumers here in California. Okay, so you have to be a member of the State Bar, and you probably already know that. Right, so then who kind of sets this guideline? It's the Supreme Court, right? So they have the primary authority over the attorneys, the qualifications to practice, the discipline of attorneys, and really they have then kind of, what would the phrase be? Delegated that authority to the State Bar, right, under their authority. So the Supreme Court could come in, and there has been, if you really follow this closely, there has been some scuttlebutt in the past few years about, you know, bar pass rates and, you know, what are the standards, and is it too high? Is it too low? You know, should they change the numbers? And there was thought that the state's Supreme Court would kind of, you know, change things up. They did not. But the State Bar really then is the one that specifically sets that, but it's under the authority that's been delegated by the Supreme Court. So the rules of professional conduct, California, so it's adopted by the State Bar, approved by the California Supreme Court. Okay, so you can kind of see that interplay there with the two groups. So if you breach, and these slides, Rick made them, oh my word. If you breach the rules, right, the Board of Governors, California Bar, do have the authority to discipline members. So this is where you hear of like someone losing their bar card or being suspended or different things. It comes from the California Bar. There is a process that works through that, but it's the California Bar. This is an interesting one. Like, where do these rules apply? Like, obviously, if I'm a California lawyer and I'm in California, like, it makes sense that the rules apply right now. But what happens when I go to Texas? Maybe I just have like a random, you know, maybe my client is here in California or our case is here, but then there's something happening in Texas that I have to go check out or get some evidence or whatever. Even when I leave this state, the rules still follow because I am authorized by the state of California under their rules. So even when I'm in other states, I still should be acting in compliance with California law. Now, if there is a situation where there's like a California thing and like a Missouri thing and they're directly opposing, and I'm in Missouri, I may need to reach out to, you know, the ethics hotline, the State Bar hotline to find out what I should do in that case. But otherwise, you should be following the California rules. And sometimes the California rules are more expansive. Maybe most states are right here and California is right here. So if you're in that other state, you're going to have to be acting out here. So there's that. Let me see. Okay. Here's like the next big one that you've probably heard about. And this is, you know, who can you associate or form a business with to practice law? And it's the Rules of Professional Conduct 1-310. Who cares about the number? A member, so an attorney, cannot form a partnership with a non-attorney for the practice of law. Okay, so that's the current rule. So it means like if my brother or my uncle or my aunt is really good at business and she knows all about how to run a business, she and I, if I'm an attorney and she's not, we cannot become co-owners of a law firm because she's not an attorney, right? So a member, meaning member of the state bar, can't form a partnership with someone who's not a member of the state bar for the practice of law. So if you, again, if you get really into studying like the business patterns of lawyers and things like this, one of the criticisms is that lawyers are lawyers. They're not trained in business. That's not their focus. And often they need really good business advice, you know, especially when you think of some of these really giant law firms that, you know, have thousands of employees, you know, across the whole country. And they say, you know, maybe we could do better if we could get a business person in here, and not a kind of business person that we pay, you know, $50,000 to give us advice for 1 year, but actually someone that we would say, you get to be an owner. And so if this business does well, you get to get more money. And if it doesn't, you know, you'll kind of fall as well. Why can't we do that? And the problem is right now, you cannot form a partnership with a non-attorney. Now you can have a hot dog business, you can have a hair salon, but you can't have a law practice business with someone who's not a member of the California State Bar in California. And just know that there is periodically some talk about changing this rule. After 2008, when that financial kind of collapse happened, there was a lot of talk, and it was looked at pretty closely as to whether or not they should revise this and allow law firms to bring in like business owners, managers. And it was after after a few years of considering, it was California did not adopt that, and I think most states did not either. But it wouldn't surprise me if what we're kind of seeing now, if that gets looked at again, you know, maybe we want a law firm and we want to develop new software or new AI programs, new chatbots, or new things to help do small cases. But I need to bring a tech person in, you know, and yeah, I could pay a tech person $10,000 to develop it for me. But what if I bring them in and we become founders in this new business venture, you know, this new law firm, right? We're the owners. I mean, it's sort of like, would that be more powerful? Would that be more successful? So that's kind of one of the things they look at. Okay. Sharing legal fees. This is kind of like a no-no again. So if you're an attorney, you may not share legal fees with a non-member, with a non-attorney. So if you ever have referral fees, and if you see a lot of the ads on TV, sometimes if you pause it and read the fine print, you'll see that, you know, it has a very complicated disclaimer about like, you're going to call someone in California and they're going to refer you to someone in Texas. And if you decide to do with it and whatever, there will be a referral fee. But otherwise, there's no fee splitting with other people. The client would have to be made aware of any sort of referral fee and would have to sign off on it. Sometimes you're like, but wait a minute, if I'm a paralegal and I'm getting paid, excuse me, running nose. If I'm a paralegal and I'm getting paid, you know, is that fee splitting? Because my salary comes from the fees we generate. That's not considered fee splitting, right? You're just being paid for your work. What you would see is like if a client pays someone $300 an hour, and then without the client knowing, you go give $100 of that to someone else to do the work. You know, they're paying you for the work, and so you should be doing the work. But you're absolutely allowed to pay for paralegals and secretaries and copy assistants, document clerks, you know, from that entire structure. So there you go. Let's see here. Ooh, we get into advertising, and I don't know how much we personally care about advertising. I'll just say this. There was a time in the legal profession when they just flat out said you could not advertise. Lawyers couldn't advertise their services. You know, some of you, if you watch I don't know if any of you watch Better Call Saul, and I am not like, I've only seen a few of the episodes, so I don't know all the ins and outs, but I know, was it like the first season or so? If anyone watches this, wait, raise your hand, chat in, let us know you're breathing. They had a whole storyline about him doing an advertisement, and, you know, it was a whole thing. But so for many years, lawyers were not allowed to have any advertisements. And so if you start to think about that, it's like, you know, if you were a member of the public and you needed to hire an attorney, how would you know how to find an attorney? Like if there's no billboard or TV ads, or, you know, you'd almost have to already know an attorney, you know what I mean? Or have friends that knew attorneys, you know, so it kind of becomes almost like a social class thing. And so if you didn't know the right people, like maybe you couldn't get an attorney. So many years ago, someone, right, you can see here the Bates versus State Bar of Arizona, this went to the Supreme Court of the United States. These two attorneys placed an ad right in the Arizona Republic newspaper with prices for certain services. And I don't know, maybe it was like forming a business or writing a trust or a will or something. And they were, the state said they were violating, right, the rules of professional conduct. And so here's the rule: a lawyer shall not publicize himself as a lawyer through newspaper or magazine advertisements, radio or TV, display advertisements in the city or telephone directories, oh my goodness, or other means of commercial publicity, nor shall authorize or permit others to do so on their behalf. So just like none, like you can't even have it in the telephone directory, sheesh. Right, very prohibitive. And they did this and it went to the Supreme Court. And in the end, they ruled that this was a form of free speech under the idea of commercial speech. So that's that first bullet point there. And they were allowed to engage in the advertising of services, as long as it complied with some limitations, but that it's legal, right? So you guys, we've only probably lived in this era, right? We live in the era of TV advertisements and I see it on the back of the buses, and sometimes billboards. Have you been injured in an accidentis? Kind of thing. So we see that. But also, imagine like if you couldn't even have a website, like if someone, how would you even list your services? So this has been an important change. But you can kind of imagine people were afraid of, is it going to be like ambulance chasers? Or people going to be scummy? I don't know. I'm sure you can find the spectrum, but I think, on par, it's probably a good thing. Well, obviously it's a good thing, but yeah. And then everyone can, find an attorney in their area, all that kind of stuff. But yeah, so at any rate, there you go. So thoughts or questions. So we live in the era where advertising, you probably never realized that was ever like a question, but there was a time where it was a question. And then Rule 1400 talks about what you can do. So they don't want you to be like in someone's face, pressuring them to hire you, right? So you don't want to solicit them directly. If someone comes to you and says, hey, I need help and this is my problem, that's different. But they don't want you like standing outside the hospital and being like, are you here because you were in a car accident? Take my card. Or standing outside the jail maybe and handing out cards. That could be a direct solicitation. Now maybe you have a billboard, on the way back from the jail, or a billboard, near the hospital. But that's not like one-on-one, because the fear is that like if you're in their face, the pressure could be too great. And so if you have a former client, a friend or business associate, those you are allowed to solicit directly, like, hey, do you need an attorney? Do you want to hire me? But as far as like the public or people you don't know, you can't directly be in their face. You can do generic advertisements, things in your local newspaper, things in your local community. This is also why a lot of attorneys will, when they're starting out, depending on what your practice area is in your business, but you'll be a member of your chamber of commerce. You'll have your office in your local town kind of community area, so that people can just see you and you go to meetings, you go to the Rotary Club, you're making contacts so that people go, I know a guy, he's an attorney and he said that he does business litigation. He says he does immigration. She says she does bankruptcies. Oh, cool. I remember meeting her at that community event, or, at that fair, sometimes they have like a community service fair. So you'll see things like that. Let's see here. I think we're only going to go about 5 more minutes. So get excited, people. Get excited. I'm like, who has joined us? Jonathan, good to see you. Max, good to see you. We're just saying hi. We're on to ethics. So, and make sure you guys are here as close to on time as you can on Wednesday. Okay. But anyway, so Rule 2-100. So now someone has hired an attorney, and this is probably, you've heard of this one. But if someone's represented by an attorney, you're no longer allowed, if you're an attorney, to communicate with the client on the other side. You now have to communicate through their attorney. And it kind of makes sense, because it's like, if I was getting phone calls and not harassed, but I mean, I feel pressure and I'm getting phone calls or letters and I'm freaking out, I have hired an attorney to lift that pressure, to lift that burden, to be the person who deals with that. So now you need to deal with the attorney, not with the person directly, right? So if you're representing a client, no one shall communicate directly or indirectly about the subject of, the lawsuit or something with someone else they know to be represented by another lawyer unless they have consent. So sometimes you can see, like in family law cases, there might be the consent just to go directly, but that has to be through, the attorney and stuff. Like, you've hired an attorney to represent you, so it needs to go through, the attorney. And that can get you, and so if the opposing party has an attorney, then you can't just go to the opposing party. You have to go to their attorney. And that could be frustrating, like, unless you have permission. So maybe if you're doing pro per and representing yourself, but they have an attorney, that means you have to contact with that attorney directly. You can't talk to the opposing party anymore, unless you have their permission. And you might, in certain situations, it just depends. But, and, a lot of family law things, they'll work out like what that permission might be, or use those special kind of chat programs to do chats about non-legal things. But yeah, otherwise you can't, you shouldn't be calling up the other side's client, if that makes sense. It should always be going through the attorney. And this would go for the paralegals as well. Unless you have permission to call the opposing side's like the client directly, everything should be paralegal to paralegal, paralegal to attorney. You should not be calling the other side, okay, directly. Let's see here. Oh, financial arrangements. So I don't know if I'm worried about this one. Again, this is a little bit of like getting back to the referral fees and things like that. So this is where, if for some reason, I'm partnering with another law firm, or for whatever reason, I've brought in someone else, again, it has to be consented to by the client. It should be absolutely in writing, very clear. Like if they're getting if it's like, I'm going to have a medical procedure, so I've bringing in another law firm to help me with my cases, or I'm getting COVID or something, so it would be very clear, it does not increase the fees. Like, you're going to pay the exact same, but now, some of that money will be going to this other law firm because they're taking over the case, or they're going to help me out for 6 months. It's not a referral fee. So there you go. And this last point is probably of a lot of interest to you. So, and this is what I'm hoping that Kai can come into and talk to you guys about. Often you kind of have two tracks with paralegal salaries, and it's worth being aware of both. You either have situations where you're fully salaried and there's no overtime. And that is pretty much not typical in California. In California, very few paralegals should be exempt from overtime. So that means most working paralegals in the state of California will be earning overtime if they work overtime. Okay. So if you are in the position where you're not exempt and you are potentially earning overtime, then often your bonus won't be huge, like your year-end bonus, because you've kind of been earning the bonus every paycheck with the overtime hours. If you work in a state where paralegals don't get paid overtime, then you might see more of those kind of bigger bonuses at the end of the year, because your work has generated more money for the firm, and you weren't getting paid any additional money throughout the year, right, through overtime or through your paycheck. So instead, you'll get that additional payment at the end of the year. So it's not a fee splitting. It's nothing like that. It's just based on your work. It's based on the total profitability of the business. So it's not based on the overall fees, if that makes sense. It's a fine hair to parse, but they do it. So, okay. So discrimination is prohibited, as you would expect, in management and the operation of the practice. And then of course, if there is a violation, besides other things you might be facing, but it could go before the bar as well. It does not necessarily, so I mean, if you're representing a client whom, because obviously everyone's entitled to a defense. So if you are representing a client who is accused and maybe eventually found liable for like violating civil rights or something, you are still allowed to represent them, right? That's not a violation. It's more about how you're managing your business, and that issue. And are some very deep rabbit holes there that you can go down. But I think as a general rule, that makes, it makes sense, just complying with like general employment issues. I think we will pause here because this is the confidentiality. And that's a good place to kind of pick it back up on Wednesday because it's a deeper topic. Oh, good. And we've got some more people here. Genesis and Kelly. Good to see you, ladies. Let's see here. So I'm just reminding everyone, and I will post this, to come Wednesday because we will be doing a Zoom class assignment and I don't want you guys to miss it or have to make it up too much. And then I'm just trying to get all of our grading caught up because I know we're kind of coming into the home stretch here, as shocking as it is, where I think, is this the last 3 weeks? Oh my gosh, I'm not emotionally prepared, something like that. So yes. Okay, I'm going to stop recording. Any questions on the actual materials or anything?